Good evening, everyone. I'm Shweta, Head of South Asia at SIAC. Thank you so much for taking out the time to join us for this special webinar on the topic, Recent Changes and Developments in Arbitration in South Asia. Please join me in welcoming our panelists for today's session, each one of whom is a prominent practitioner in their respective jurisdiction. The session will be moderated by Mr. Nish Shetty, Partner and Head of Litigation and Dispute Resolution for Asia Pacific at Clifford Chance. Before we commence today's session, I'd like to request you to post your questions using the Q&A function on your screen. We'll try and take as many questions as we can. Without further ado, I will now hand over to Nish to conduct the session. Nish, please.
Thank you, Shweta. Good evening, ladies and gentlemen. Thank you for joining us for this webinar hosted by SIAC. As Shweta said, the topic for discussion today is recent changes and developments in arbitration in South Asia. Now, as many of you will know, arbitration has become the preferred mode of dispute resolution for commercial matters in many parts of the world. Many countries have introduced the answer trial model law into their domestic legislation. International arbitration is growing in popularity for the structure, predictability, transparency, and confidentiality that it brings with it. Institutions such as the SIAC are charting new paths for the practice of arbitration law, and they regularly update their rules of procedure to be there with the most current thinking in terms of international arbitrations. So how much of these global changes that we're seeing in the international arbitration world has found its way into South Asia? To answer that question, we have an excellent panel of speakers from key jurisdictions in South Asia: India, Pakistan, Bangladesh, and Sri Lanka. Given the paucity of time, I will do a very quick introduction to each of them. Their detailed CVs are on the net, and I'm sure you can look at them at your leisure. So from India, we have Senior Advocate Pinky Anand. Pinky was formerly the Additional Solicitor General of India. From Pakistan, we have Senior Advocate Makhdoom Ali Khan. Makhdoom was the former Attorney General for Pakistan. From Bangladesh, we have Advocate of the Supreme Court Imtiaz Farooq. Imtiaz was a lecturer in Cardiff University before returning to Bangladesh for his advocacy practice. And from Sri Lanka, President's Counsel Avindra Rodrigo joins us. Avindra is a barrister at Gray's Inn and the head of the litigation division of his firm. So I'm going to help moderate this particular session, but I'm sure you're all waiting to hear from the panelists on the various matters that we're going to be discussing in the course of the roughly hour or so that we have for the discussion. And we're going to try and keep at least 15 minutes for Q&A right at the end. Now, that's not to say that you need to keep your questions to the end. As Shweta said, you can write in using the Q&A function, and we will try and answer as many of those in the time that we have. So just to give you a sense of what the structure for the discussion is going to be like, in the flyer that you would have seen from SIAC, it had four broad topics. It identified four broad topics: legislative changes that have taken place in South Asia that relate to arbitration law. That's the first. Institutional arbitration, court decisions of note involving arbitration law, and finally, developments in the treaty arbitration space. So that's the broad sort of structure. Now, within that structure, we will try and delve as deeply as we can into the various sort of sub areas. We may also go into some other subtopics if time permits, but for the moment, we will focus on these four core areas. So starting with the first one, which is legislative changes. I can say, as an interested observer of this space, sitting in Singapore where I'm based, but traveling quite often to many parts of the region, including many parts of South Asia, I would say that it's heartening to see some significant changes happening in the legislative landscape reforms in relation to arbitration law in many jurisdictions, and in some other parts, an identification of issues, but not necessarily taking the same steps as others have in their respective jurisdictions. So enough from me. Let's hear from the panelists. And for the first bit on legislative changes, if I could ask Pinky to tell us a little bit about India and how and what sort of legislative changes we've seen in terms of arbitration law in India. Pinky?
Thank you, Nish. Indeed, it's a very remarkable feature that India has been ultimately grappling forward with handling arbitration and becoming the arbitration hub as far as South Asia is concerned. So believe me, Nish, that we've had a complete series of wide-ranging changes stretching across from 1940, where the Arbitration Act came into being, right up to 2021, when the changes have taken place. And I will add to that, and I'll come back to the legislative changes itself to say that not only have we had tremendous amount of legislative changes qua statute, but we also have had the courts and the justice delivery system step in to try to import values and pro arbitration issues from other jurisdictions, even where there has been some areas which might be lacking in explicit provisions. So, I mean, of course, everybody has heard, and we'll come to that later, but for example, emergency arbitrations, and I'll just flag that and leave it there for a subsequent discussion, because I think that has been an area of immense interest as far as the world is concerned, and definitely for measures which protect the investor and the parties in question. But coming back to the Arbitration Act, of course, our Arbitration Act is modeled on 1985 UN Citral, and we have followed the general pattern throughout. We recognize the New York Convention and the Geneva Convention for purposes of execution and enforceability. But the main changes, so let me just flag what I feel are the most important ones and have stretched across the surface to give us the background and the landscape to import further value systems. And I'll also flag third-party funding, by the way, as a subject, which is of immense interest to me. And I did try my best to take it forward explicitly, but it's still in the roll call. So the 1996 Act, the first amendment out of the four that I was mentioning, brings in conciliation, which of course was necessary and mandatory. And recently the Chief Justice of India, in an ICA-sponsored arbitration in Dubai, by the way, flagged both conciliation and mediation as a very important platform for resolving. And I think he referred to R.L. Stevenson, where he said compromise is the best and cheapest lawyer. But that was one of the major flags of 1996 Act, aside from the fact that we started limiting, and that's when the ball started rolling, the judicial scrutiny process. Because the whole idea of arbitration awards being final is something that everybody was looking forward to. And for purposes of assuaging the confidence and to inspire confidence, rather, of the investors and everybody else, the question of limited judicial scrutiny, upholding the finality of the award, is something which came into being in 1996. 2015 is the next series of major changes that came around, where we started defining timeframes, because ultimately arbitrations took a considerable period. So to try to reduce the timeframes and to limit the time within which it would be held, we used to have automatic stay. So the minute awards were filed, there would be an automatic stay, which ultimately, or rather the petition for challenging, the arbitration awards, you would have an automatic stay. But that ultimately, 2015 amendment said no automatic stay. Now we've had a slight deviation, but I'll come to that a little later. We started having disclosure about the independence and the impartiality of arbitrators. We started having the application of interim measures to foreign awards. I think that is one of the most significant changes, because ultimately we are in a world of international commercial arbitration, and we are looking at inter-country arbitrations, and definitely all the jurisdictions that are represented here, as much as which are not represented currently, but which would be important for our purposes, is something that was important for the purposes of enforcement. We started having the question of restricted public policy issue, which restricted it immensely. So unless it was induced by fraud or corruption, earlier it was only public policy, started being restricted further. It had to be a contravention of a fundamental policy of Indian law. No case for review on merits. So you didn't have a second bite at the cherry, as they say. And ultimately, a number of judgments now have dealt with this issue. And then we went on to 2019, which brought about the major changes for institutional arbitration, and we'll of course come back to that subject also, but the Arbitration Council, which looks to monitor, supervise, regulate, and provide the various prescriptions for the arbitrators as much as for the institutions, the qualifications of experience of arbitrators, confidentiality. We limited timeline a bit because we found that for foreign awards, we couldn't have a definitive timeline. It had to be left to the discretion, hoping that it will be done expeditiously. For domestic, it was expanded because some issues have come up regarding that. And finally, 2021, we had the provision for foreign arbitrators to practice in the Indian jurisdiction, which of course is of immense significance for all of us here. And the second point, which I had mentioned, that ultimately in a case, even though automatic stay had been taken away, stay was brought in, an injunction, when there was a case of fraud or corruption. Then the court had to grant, shall grant an automatic stay of the execution of the award. So I think this broadly reflects two things. One, the desire to bring in each of these propositions of arbitration into the modern world and to make available all the possible methods of enforcing it. Secondly, to reduce judicial intervention for finality. And thirdly, to improve, of course, any form of institutional mechanism. So broadly, this is the landscape of the legislative changes which India has been doing. The Law Commission on the 176th and 246th reports ultimately had suggested, which came in ultimately in this fashion.
Thank you, Pinky. That was an incredible canter through almost 2 decades of arbitration law. So well done. Just a couple of observations from my side, if I may. I remember the time frame issue being introduced in 2015. And for the benefit of those in the audience that don't know what this is specifically, and you know, Pinky, do correct me if I get this wrong, but my understanding is that effectively the amendments to the act made it mandatory that certain timeframes would apply. At first instance, an arbitration needed to be concluded within 12 months, extendable to 18 months by agreement of the parties, and after that you had to go and get court approval before you could get more time to render the award. And I can tell you internationally, that was met with much skepticism when it first got introduced, because people said, how will you know how long an arbitration is going to take? You make it part of your legislation, and all of a sudden what's going to happen is people are going to breach that and end up back in court. But from my friends who practice in India, I'm told that hasn't been the problem. In fact, most have welcomed this move to have sort of defined timeframes. And by and large, I'm told that in the Indian domestic arbitration environment, both arbitrators and counsel are respecting these timeframes and trying to conclude matters within the stipulated timeframes wherever possible. And just to before I get your sort of comments on it, to draw a distinction between that and the litigation process in India, which is, let's just say, significantly longer than the 18 months or so that we're talking about in this legislation. So Pinky, any thoughts or observations on what I just said?
No, you're right. In fact, I mentioned that in 2015, when we had it, the foreign awards, particularly the bar which dealt with that particular part of the surface, did have grave objections because it couldn't be limited. And that's why there was an amendment in 2019, which delinked foreign arbitrations in the strict time frame, expected them to perform within the expeditious limits. But yes, the time limit was absolutely essential. And yes, you're correct to say that arbitrations in India are being conducted in accordance with the timeline. And there is, in fact, a cost and a penalty that is imposable if it is not. So definitely tax is a major incentive. And we needed this spur, let us say, within the system, and the legislative changes is very, very welcome, because you do hope that things will get done within time. The major surface of arbitration is expeditious disposal. And if you can't achieve that, then you can't achieve almost any object in that. So definitely a timeline was a major welcome effort, and it has well succeeded into most arbitrations. I'm handling several, and I'm conducting several, both on both platforms. And I find that we are definitely keeping to the timeline. I keep looking at the date when the arbitration with the reference came in. So to say I have to conclude it within time. So it acts as a major incentive, and there's a disincentive for not concluding it. So be it.
Thank you. Let me now ask Avindra if you would tell us a little bit about how the legislative changes, if any, have been taking place in Sri Lanka.
Yeah, thank you, Nish, and thank you for having us again. I think what will be useful is if we first look at how Sri Lanka introduced arbitration in the way that we presently know it into Sri Lanka by the 1995 Act, more than something like 25 years ago. And the act that was promulgated at that time and is still in force is an act that provided, shall I say, the bare bones of legislation with important features, I have to say, but the bare framework of legislation for assisting and providing for the foundation for the conduct of arbitration proceedings in Sri Lanka, as well as enforcement of foreign awards. The most important feature that was introduced, and I think Sri Lanka was one of the first countries, at least in this region, to have that, was to remove almost entirely the jurisdiction of court where there was an arbitration agreement. And that, I know certainly we were ahead of most of Europe at that time. Perhaps some of the other countries, other speakers, we talk about what the situation in this part of the world is, but certainly we were ahead of the West when we introduced this. It wasn't the case of staying proceedings, none of that. We just removed the jurisdiction of the courts completely if there was an arbitration agreement. And with that sort of bare bones framework that we had at that time, I have to say that we have been quite successful in conducting proceedings in Sri Lanka, as well as enforcing foreign arbitral awards within Sri Lanka. Two issues, though, did surface. So the Vista Act didn't provide for detailed provisions on the conduct of arbitral proceedings. It also didn't have any provision for what Pinky already alluded to, that is the emergency arbitrations and the enforcement of interim awards. So problem that surfaced very quickly was, what do you do pending the constitution of the tribunal? And our courts, in fact, stepped in and provided that you could go to court pending the constitution of an arbitral tribunal and obtain interim relief from court pending the tribunal being so constituted. So that was one of the issues that we had. And the other was the enforcement of anything other than a final award, because that was again not dealt with by our earlier legislation. So these two issues are both being dealt with by the draft legislation that we have now in place. Well, not in place yet, it's still in draft form, which is being discussed as we speak. And these two issues are both being addressed. That is, that emergency arbitrations to be conducted within the framework of the Act, and also that interim awards may be enforced just the same as a final award, and these two taken together, that is, suppose you are in a position where you can't have the full tribunal or the final tribunal constituted, you have an emergency arbitration and you have an award within those proceedings, which then can be enforced under the provisions of the new law for enforcing an interim award, and you would then end up with the results that you wanted. Two results. One is that you won't have the need to go to court at all pending the constitution of the tribunal. That's one. And number two, you will be able to enforce the arbitral award, even if it's an interim order that is made. Yes. So these are the two significant provisions that are being discussed and are actually in our draft arbitration bill. And we are also looking at putting more detail into the conduct of proceedings within the Act, which we didn't have previously. Though I do have to say that not having it did not pose a significant problem. I presume that having such detail is also not going to provide a problem. But as it is, that is our status. We are hoping to have the Act finalized in the next few months, at least the bill, the draft of the bill, and then it will be put through Parliament. So after 25 years, we'll have legislation which is only a development, but not a significant departure from what we have already in place. Yeah, that's what I would say, Nish, about our current situation.
Thank you, Avindra. Very clear, very clear. And I hope that the bill passes soon. I mean, your point about the need for an act to have procedural rules incorporated into them. I mean, it's interesting that we're discussing it, because I think India, as far as I'm aware, was the first one that did that through the adoption of the IBA guidelines as a schedule to the amendments in 2015. Again, the international community did sort of look at that and say, you know, was that really necessary? Because most other jurisdictions leave that to the parties to decide whether you want to go to an institution like SIAC, for example, which has very detailed procedural rules that you can rely on to have, you know, structure to your arbitration, and that works perfectly fine. I guess where the gap is when it doesn't go to institutional arbitration. And as in India, where there are a lot of ad hoc arbitrations, then having some structure, some procedure put in place is better than not having it. But I don't know what your thoughts are on that.
Sure, certainly. I appreciate that having a structure is great, but again, the point that you made about party autonomy and leaving it free to the parties to decide. And really, do they have to decide? They may prefer not to pick a set of rules from any institution. They may like to make it up on the way. That is, arbitrators themselves can set down by orders for directions and so on, the whole set of rules that are going to be adopted for that specific arbitration. So even an ad hoc arbitration can take shape subject to the arbitrators doing that. My personal view is that it is better to leave it open, respect party autonomy, rather than putting in too much detail, or certainly not importing a particular set of guidelines from the IBA or anything else into a statute, which will automatically take place in an ad hoc arbitration. And that's the way we have our present legislation, as well as the new legislation, which is also only providing basic processes, but not beyond that. Yeah.
Thank you, Avindra. I'm conscious of time. Just moving very quickly to Makhdoom first and then to Imtiaz. Would you like to give us an update perhaps on what's happening in Pakistan, Makhdoom?
In terms of legislation, we are still stuck with the Arbitration Act of 1940 when it comes to domestic arbitration.
Right.
On international arbitration, the New York Convention Act and the ICSID Convention Act, Washington Convention Act, have been incorporated. So international arbitrations enforcements are relatively quicker, but there are steps afoot for reform of the domestic law. Unfortunately, no incentive or initiative from the state, but lots of private lawyers groups and younger lawyers in particular are lobbying for legislative reform to bring in, let's say, an ancestral model law kind of a statute for domestic arbitration. But all these attempts are fairly nascent at the moment.
Thank you, Makhdoom. And finally, Imtiaz from Bangladesh perspective.
Bangladesh, we have a law which is based on ancestral model law. we had one amendment made to give the court powers to give interim measures. But there is a long need for a lot of changes. And most recently in December 2021, the Law Commission has come up with a laundry list of changes that they would like to see in the legislation, and they have also published a draft law. So I would like to spend a little bit of time on that proposals. So what they are doing, what they have done is they are trying to follow India and bring in a lot of these time frames brought into. And one of the key things that they have brought in from India is this 1 year time frame to finish arbitration, which can be extended up to another 60 days. But where I think it sort of falls short is that it does not say what happens if this time limit is not adhered to. So in other words, like in India, you have to go back to court to get the sanction. Here it is silent. In Bangladesh, the jurisprudence has been whenever there is a time frame in the legislation which is not backed by a sanction, it is termed as merely directory and not mandatory. So I think if this law is to be enacted as they are suggesting, I think we may get into that sort of. And personally, I think we have to, and the act is also the proposals of Law Commission is not also very clear as to how the time frames will sort of pan out in terms of institutional timeframes that are there. So whether, which one will take precedence. Another important change that is being suggested, and I think which sort of goes hard to the principle of doctrine of competence, globally, is we have a section which is similar to Section 32 of English Arbitration Act 1996, which gives the High Court power to look into jurisdictional question where if it saves money, time, etc., etc. Now, what the Law Commission has sort of gone without explaining the reason is to say that if the tribunal has given decision on its own competence under the doctrine of competence, the equivalent section, still that question can be looked into by the Supreme Court or by the higher courts. Now, I think that is a big, that will put a big lot of cloud on our credibility of arbitration, because, one of the things, one of the selling point of arbitration is that let the tribunal decide these matters, let's not, try to question their jurisdiction or an existence of an arbitration agreement, etc. So if those issues are dealt with by the tribunal once, and then you bring it back to court, I think that that is a step backwards and not forward. But otherwise, I think need for use of technology, the use of instantaneous method for service of notice, etc., are probably welcome change in this draft. So let's see how it is taken.
And I don't want to put you on the spot, but any idea when you think, with a fair wind, this will become law?
No, I think Law Commission reports not always get into law unless, of course, arbitration is a specialized matter. So when they have given such a lengthy draft, and there have been talk of some changes in the legislation, but I think still government needs to, the law ministry hasn't yet sort of given any indication as to how they were going to treat these proposals.
Thank you, Imtiaz. Was there anything else anyone wanted to say after hearing the sort of feedback and comments from the various jurisdictions? Does anyone want to add to what they've said before on legislative changes, or indeed the need for further legislative changes in one or more of these jurisdictions? Anyone?
Only to say that when we are looking at arbitration, the less legislation, the better is, I think, should be the norm, because really we are moving out of whole idea of courts and legislation and all of that, and having party autonomy and them having their disputes decided there. So it's somewhat of a contradiction for the legislature to get too involved. Only to say that, yeah.
Maktoum, you have your hand up.
Yeah, in the case of Pakistan, I would say that to the contrary, we need some legislation now to update our domestic arbitration regime. Thereafter, probably we are a long way away from less legislation. We need to get the ball rolling.
Well said. Thank you.
I just want to add that I'm between the two. So I don't agree with Avindra for the reason that if you don't have a legislation limiting the role, and particularly the interference, I suppose, in the awards, which we want to enforce, we would have trouble in our jurisdictions. So we do need to have that in order, because there is this entire landscape which is developing on a new narrative, which is what we want to take forward. On the other hand, of course, compared to Pakistan, we've had a tremendous amount of sea changes, and we are still, however, Nish, while we looking for further developments and to improve our system so that we can deliver even better to the international community and to the domestic community.
Yeah, just to add, I mean, I quite agree that you have to have some legislation. What I was trying to say is that it should be as limited as possible. I quite agree, though, with Pinky that you must have something that provides that basic framework. And we have managed so far, apart from a couple of obstacles, as I said, on a basic framework. Yeah.
I guess if I was to sort of summarize what I've heard from all of you is that the legislation needs to exist, and it needs to facilitate arbitration. It needs to ensure that there's very little judicial intervention, and thereafter arbitration can promote party autonomy and promote the sort of the reasons why parties choose arbitration in the first place. So would that be a fair summary?
Absolutely.
Absolutely, yes.
Now, going beyond legislative changes to our second topic, and that is really institutional arbitration compared to sort of ad hoc arbitrations. Now, obviously, we've been invited by an institution to this particular webinar, but I know that SIAC is all about thought leadership, and there's no sort of whip here saying that we have to take a particular position. So I think really what we should explore is institutional arbitration and its role in the overall sort of arbitration landscape. Avindra, you mentioned earlier that sure, an ad hoc arbitration can serve its purposes quite well as well, particular purposes quite well, because you can tailor it to the needs of a particular dispute. Now, on the other side of that particular equation, you have a whole load of ad hoc arbitrations that result in significant delay, much uncertainty as to procedure, and parties end up being quite anxious that there is an open-ended blank check, as it were, which you're not able to control because you don't want to offend the arbitrator that's going to be deciding your dispute. I'm not suggesting one is better than the other, because that's not my role. So over to whoever wants to take this first up. Institutional arbitration and its role in the arbitration landscape. Who wants to go first?
I'll take this.
Sure, thank you.
So Nish, I mean, you've actually summed it up so well that it's difficult to get out of it. And of course, the fact that we are being hosted is one factor. But honestly speaking, I have been handling both institutional and ad hoc arbitrations, and there's a world of a difference. So aside from the skepticism or uncertainty that the party may face in ad hoc, the fact that you do have certainty prevailing as far as the system is concerned, the necessary infrastructural backup, even though in COVID times it hasn't been infrastructural, but more the electronic and the telecom kind of principles that are prevailing. And it's actually handled itself very well, I must say. So, I'm working with the Indian Council of Arbitration, which is the oldest body, which actually regulates. So there's a registrar, there's an entire team which is there to put everything into perspective. So you are really doing the role not of any administration whatsoever, but doing the, if you like, the judicial side or the adjudicating side. Because it's arbitration, we may not use the word judicial necessarily. So that really puts it to promote that. So India also has been actually heading up its own way into the institutional mechanism. And that's why when I was mentioning amendments, in 2019, the Arbitration Council of India, for example, is a regulatory, not only regulatory, but a supervisory body, and a necessary body which bolsters up the entire institutional mechanisms, is something that has been mooted, which will be set up by the central government as a body corporate. And the idea is to have definitions, to have programs, to have everything that goes to make the system work more efficiently. So that is a feature that has been inbuilt into our amendments and the legislative changes, which we hope will take forward. The number of institutions in India, incidentally, and I have in fact also been one of the founders of the BRICS Center for Resolution in India, but you have the Indian Council of Arbitration, primary ones I'm talking about, the Delhi International Arbitration Center, the Maharashtra MCIA, as it is called. Recently, the Chief Justice inaugurated the Hyderabad International Center. In fact, programs took place in Dubai, where the conference took place just about 3 weeks back. And there is talk of one in Gujarat. Of course, we have a large country, so we need to look about territorial jurisdictions for arbitration centers, even though outside COVID times, we may actually do things physically. So having said this, the broad advantage definitely of institutional arbitrations is immense. It lessens the burden on the arbitrators as much as inspires confidence in the parties to feel that there is a set framework. Yes, you're right to some extent to say that you don't have that simplicity which you want in arbitrations at time to fast forward the process and to adapt and tailor it to the needs of the parties' disputes or requirements. But at the same time, I think arbitration by itself is a flexible approach. And even in institutional arbitrations, basically the arbitrators do set out their procedures, and if procedures are defined, there is no harm. You have a certainty in definition. That always works better.
Indeed, I mean, in the context of an institutional arbitration, your first procedural conference is where you set out typically the needs of a particular arbitration. So if there are aspects, expert evidence, for example, is something that may get dealt with. So you need to introduce that into the arbitration. There's certainly avenue for that as well in the context of an institutional arbitration. I saw Maktoum's hand up. Was that the old?
Yes. Well,
okay.
We don't have any institutions at the state level. There are attempts being made again at the private level to set them up. Domestic arbitration remains more or less a cottage industry of retired judges practicing it at an ad hoc level. The change which is taking place is that in many of the big, even domestic arbitrations, people are now accessing, let's say, LCIA or SIAC or ICC. There is always that fear and issue of costs. That is being handled now by having, let's say, a seat in London or Singapore, but keeping the venue by agreements of the party within Pakistan and making the applicable law, even if it's a foreign law, keeping the venue in Pakistan. So that brings the cost down. At the domestic level, again, groups of young lawyers like SICA are trying to set up institutions which hopefully in a few years' time will take off together with legislative reform.
It's great to hear. Thank you.
Please, may I come in there?
Please.
Yes. So I quite agree that there are huge benefits with an institutional arbitration. Firstly, the whole administrative mechanism that is available, which is obviously of huge value, and particularly in a large arbitration. As Maktoum mentioned, the costs obviously are relevant, but the type of dispute that would, where there would be an institutional arbitration clause would probably be something that is of a larger financial value, and then it'll work out commensurate with the benefit that you get from the whole administrative mechanism that you get from an institution. And that's obviously invaluable, and that cannot be replaced in an ad hoc system. The other big advantage is when it comes to the appointment of arbitrators. So if you just have an ad hoc arbitration and there is no recourse to the panel or the institution or the court of that institution, which will appoint an arbitrator, that's again a big issue that can arise at the initiation of a arbitral process. Then again, when it comes to challenges, where you can have again recourse to an institution if you have an institutionalized arbitration. So these are the critical aspects I would say that an institution brings in, that is administration and appointment and challenges to arbitrators. Certainly the predictability and so on of it also is of value. It can perhaps be to some extent substituted with orders on the way, but obviously the detail that you have in a SIAC set of rules, for instance, you won't get in orders for direction. So that's the way I would look at it, that the principal parts of it are what I just mentioned. And the administration should certainly not be undervalued, because we have had recourse to institutions just for the administration part of it, even if it was not under their rules. Yeah, so some institutions have helped us, and that has been of great value to us. Yeah.
Thank you, Avindra. Imtiaz?
Hi. So in Bangladesh, it's a bit like what Mukdum Saab was saying, that arbitration has been more or less sort of for retired judges to do, and that the result of that has been that it has become a very expensive process. And recently, I saw a litigation at the highest court, and where the court was very embarrassed kind of thing, where one party was complaining about how the arbitrators are charging so much, and they are charging at their own free will. Now, under our Arbitration Act, the concept of institutional arbitration is very much promoted and accepted. But we have, in these 50 years of our journey, have just only one institution for last 11 years, which is BIAC, which is a somewhat proper institution. But their role also have been mostly limited to giving infrastructural support or venue support kind of thing. I think only they have till date only one arbitration under their rules, and a couple are coming. So I think it is important to understand, but if you see it internationally, institutional arbitration is the way forward. You know, is the go-to person. No one talks about in a big international contract, they wouldn't give ad hoc arbitration because no one likes that kind of uncertainty. So we have this. So I think initially, to make arbitration popular, having ad hoc arbitration was great. But now if Bangladesh wants to graduate to the next level, we need to make international institutional arbitration popular. Like in India, you have a number of these institutions. I think the concept of a advisory, supervisory, regulatory, whatever body you have in India, I think that is not a bad thing for us to sort of take away and see whether we can. Now, government is, very recently said that, okay, they are going to give a grant to BIAC, and they're trying to promote. But I think, people need to be very serious. They need to try to put the development of institutional arbitration at the forefront, and also see how it can be made more affordable for people to come in. So the only big reason people run away from arbitration is cost. And I think this is the answer to that question.
Yeah. Anish, can I just add one other point there? Yes.
Please
if you look at this, most of these arbitrations that we've been talking about will be international arbitrations. And in that situation, the parties would much, much prefer that an independent institution is involved in things like appointments, challenges, substitution of arbitrators, and so on, rather than having to go to the courts of a country of one of the parties to have that effected. So that's another huge advantage in having an institutionalized arbitration, that you keep it out of the local court's jurisdiction and keep it independent, which I ought to have mentioned, I think, earlier. Yes.
No, thank you, Avindra. I mean, I think, the debate in relation to international arbitrations, where one party is a foreign party, on that front, I think the debate is pretty much in favor of a neutral seat and a neutral institution by and large. Okay, it's not always the case, but by and large, I think the debate has gone in that direction. Is there a role in the domestic context where you're dealing with two nationals who should, I guess, be comfortable going to the national courts? In many places, we still see arbitration as a popular dispute resolution mechanism, even for domestic disputes. Do you think that that is something that should be encouraged?
Well, for me, I think that domestic disputes, you may have a set of domestic rules which are cheaper perhaps than a larger institute's rules and administration by a larger institute, in which case you could have recourse to that. We actually have one in Sri Lanka, but I'm perhaps going into the other topic there, which is pointed out there. But for domestic disputes, which tends to be smaller in value, to have a set of SIAC rules or a SIAC administered arbitration or ICC or LCIA, whatever, I don't think really makes a lot of sense, I have to say.
Or indeed what Pinky was talking about. It needn't be a SIAC, it needn't be an ICC. It could be the Gujarat center that she was talking about, or the Hyderabad center, or the Delhi center, or whatever, right? Is there a role for institutional arbitration in the context of ad hoc disputes locally, and sort of local institutions to sprout and perform that particular role?
I think niche, at least in Bangladesh, is very much needed, because if you now people are aware of arbitration, they like arbitration as an alternative method. But if you have to pay millions to former judges and expensive lawyers for ad hoc arbitration, which is the norm, then it is difficult. If you have local institutions with good arbitrators listed there with fixed fee schedule, things, then it will be more encouraging. So like our financial institutions, etc., for loan recovery, etc., I mean, they can use this kind of thing. So I think there is a huge market for local institutions to grow, and then for international institutions, there will be an appetite or that trust on the jurisdiction that yes, things work here. I think at least from Bangladeshi context, I think it's very important.
Pinky, you have your hand up. Thank you, Imtiaz. I think you're on mute, Pinky.
Just to respond, Nish, to your particular statement on domestic arbitrations, I was just looking at the figures of domestic arbitrations and finding that institutional arbitrations have been utilized, and possibly for two reasons. One, you have a schedule of fees which is fixed. Firstly, you have it in the Arbitration Act by way of an amendment that a schedule was set, which applies. And the ICA, for example, I mean, the arbitration fee is fixed, so therefore people are decently happy to take an avail of those kind of fees and not go to the higher fees, which is one of the major issues. Even during COVID times, despite the small kind of downfall on the numbers of arbitration, for example, again, ICA has seen a tremendous increase, and more than ICA, even DIAC, the Delhi International Arbitration Center, went from about 2,000 in 2017-18 to about 4,500 domestic arbitrations in the last year. So I think it demonstrates for itself the efficacy of the system. But you're right, unless you have it controlled by costs, people would not be able to afford it, and therefore would stay away from it and hope to go to ad hoc. But then if you again go to judges and who are paid highly, then you have that question mark and that entire area open.
Actually, yeah, I'll go to who was the one that raised the hand? I think it was Maktoum. I'll come to you, Maktoum, in 1 second. I was just going to make one observation, and that is, when people talk about costs of an arbitration, your principal costs would be your counsel and your counsel team, your arbitrators, and then the institution. In my experience, the institution's charge is relatively small compared to what the lawyers charge and the arbitrators charge and the counsel charge. But yeah, it needs to be commensurate with the value of the dispute. If not, it doesn't make sense. And it's where I guess the various rules of the various institutions which provide, for example, for expedited procedures, if for low value disputes and so on, that's their attempt at bridging that gap. Magdum, you had your hand up.
Yes, I second what Imtiaz Farooq and Pinky said. I totally agree with that. Domestic institutions with a schedule of costs where people know what they will have to spend in order to get the dispute decided will definitely be helpful. The other thing is that the courts are exceedingly slow and there is nothing in sight which may suggest that the speed of the courts is going to increase anytime soon. So this will take a considerable burden of deciding many commercial disputes off their shoulders. And these can get decided more expeditiously in that the courts will have to cooperate by being a little less interventionist and a legislative framework which encourages and institutionalize such relatively less intervention.
Well said, Magdum. In
Yes.
fact, that's a good segue into our next topic, which is really sort of arbitration-related court decisions of note. Again, can I? Well, I don't know, Pinky, whether you have that hand up from before or you want to take that point, but I'm happy to sort of start with you if you'd like to, unless someone else wants to.
No, thank you so much. The hand was from before, but nonetheless, let's take the cue from here. Frankly,
Okay.
it covers some territory when we're discussing legislation amendments by limiting the judicial intervention issue and by reducing or limiting again the public policy defense that is available to oppose the enforcement of arbitral awards. So having said that, I think by now, because of the legislative changes, we've had a sea change in the way that awards are dealt with in courts. So I know that there has been always an apprehension of foreign parties, for example, or in the international commercial arbitration, that the field is open and there is a tremendous scope for arbitration, for interference by the judicial system. Having said that, I think we've really narrowed it down, Nish. So we have a system whereby public policy has been defined as something which is not would not apply unless and until, for example, you have fraud or coercion, unless and until it is in contravention of the fundamental policy as far as India is concerned, unless and until it is tainted by other features. We do not have a review on merit, so that bite of second cherry. And if I may just, for a moment, read out a short kind of 4 lines from one of the recent judgments, and we've had a spate of judgments, which really limited to, for domestic patent illegalities in addition. For foreign awards, that is not by itself a ground. The others are otherwise similar. So I was just looking at the Delhi Airport Metro Express, which is a major contract, of course, regarding an airport line and metro, and where there was a problem and termination happened. In that context, and while dealing with the award, the court, the Supreme Court of India says, patent illegality should be illegality which goes to the root of the matter. In other words, every error of law committed by the arbitral tribunal would not fall within the expression patent illegality. Likewise, erroneous application of law cannot be categorized as patent illegality. In addition, contravention of law not linked to public policy or public interest is beyond the scope of the expression patent illegality. What is prohibited is for courts to reappreciate evidence to conclude that the award suffers from patent illegality appearing on the face of the awards, as courts do not sit in appeal. So I think this kind of, I can go on, but basically it tends to limit it to the grounds which have been limited itself. And Nish, just to share with you, I did a comparative assessment of public policy defense in arbitration and the New York Convention when I was at Harvard. And of course, we did find that it gave itself tremendous scope for interpretation unless and until law limited the scope. So really, it's an effect of the position of that law has taken and legislative changes to limit the scope, which in most situations, courts are keeping to, and increasingly are finding more minimal interference or almost no interference, excepting in exceptional cases. I do know, for example, the courts will say, well, there are 2 views that an arbitrator can take. Well, so be it. Then there's no reason for us to decide which way they should have gone. So each of these features actually lends itself to the credibility of the system to say, we want the arbitration to be a finality. And unless and until natural justice is affected of tremendous nature, unless and until there is public policy, the fraud and corruption, of course, have been made an extreme ground. And that is a recent religion because of what has been happening in the past to some extent. But save and accept these exceptions, the scope of interference is being limited increasingly day by day. And the rare chance that the awards are being interfered in are fairly exceptional cases.
Yeah. Now, Pinky, I mean, it's it's very heartening to hear a senior Indian practitioner describe these passages from Indian judgments, because it wasn't that long ago where the unruly horse of public policy was sort of trotting all over the Indian courts, and you had judgments going both ways. So I think since Balco, I would imagine, it's I can't remember when Balco was, but
2012.
I think in India you've had a clear direction set on limiting the use of public policy as a tool to challenge the arbitral process. But again, if you look back at the development of international commercial arbitration, and you can pick the jurisdiction, you can pick London, you can pick Singapore. Each of these jurisdictions went through that same process. The judiciary needed to accept that there were others that the parties empowered to make decisions, and those decisions should bind them, regardless of what that judge thought the decision ought to have been had he or she looked into that same case and looked into those facts. And I guess public policy is just one example of sometimes the reasons used to arrive at a different decision to perhaps deliver justice in the views of some courts. But like I said, all I can say is it's a very, very encouraging, and I'm sure many other jurisdictions will be hopefully going down that same path and accepting that arbitration is largely a standalone process chosen by the parties. So I should keep quiet now, and Imtiaz has got his hand up. And did you have something that you wanted to raise on this point?
Yes. So I think great to hear from Pinky the Indian direction, and fortunately Bangladesh, Supreme Court is also down that path, and in a recent case they have again in defining public policy. They chose a narrow definition, and they said that contrary to public policy means having a negative impact on the state and whole society. So just because something is not contrary to even illegality simpliciter doesn't mean that it is contrary to public policy. So contrary to public policy has to have a wider negative impact on the state and the society. Thereby, the threshold has been set to very high, and I think that gives a lot of comfort to investors when they look at, okay, I have a foreign award. What impediments do I now face? And I think now we have some form of guideline, maybe perhaps not as much as as clear as in India, but some form of guideline to sort of rely on, even to advise clients that, okay, whether you can, because this question may be asked at a much earlier stage than the dispute. At the investment stage, the investors would be asking that what would happen if I get an award? And I think it is at least a step forward to get such kind of guidance from the Supreme Court, which will, again, we can then build upon. So I think from a public policy definition perspective also, we have, and that was one of the reasons that I had raised my hand while Pinky had started sharing her experience.
Thank you, Imtiaz. I'm conscious that we are now at the time that I said we're going to start taking Q&A, and we haven't covered a few points. We haven't touched investment treaty, which I really think we ought to, and we haven't touched on, related to this court decisions point, on emergency arbitrations. So if you could just, so what I also have been doing is monitoring some of the Q&A. So I'll try and weave in some of the questions that have come through as we go into these two topics. But can we just touch perhaps on emergency arbitration orders very, very quickly? And really here, I guess the topic is around what, how enforceable are emergency arbitration orders in your respective jurisdictions. I think there's a recent Supreme Court decision in India. Do you want to just touch very briefly on that, Pinky, and then I'll go over to perhaps Maktoum after that, whether this is something that you see in Pakistan, and we'll go to investment treaty straight after that.
Yeah, thank you, Nish. You're right. I mean, I mentioned Amazon versus Futura, which was a SIAC arbitration. Nonetheless, incidentally, Nish, it was a domestic seated arbitration for all purposes. And you know that seat and venue debate has been hotly debated about in India. I won't stretch there for the time being and leave it to emergency arbitrations. But Amazon itself really decided the field that emergency awards, there were some Delhi High Court and Bombay High Court judgments earlier, also dealing with foreign seated arbitrations. But Amazon actually decided the field to say, yes, if there was an emergency award, it was an award which is enforceable, because in any case, a law puts interim awards, and interim awards and emergency awards are equatable, broadly on the same principles. Of course, there is some difference, and I do think we need to kind of tweak everything into a proper perspective as far as law is concerned. But the Indian Supreme Court dealt with the issue at length, and a very, very detailed judgment has held that emergency awards are not only something which are acceptable within the arbitration framework, but enforceable. And the injunction which is granted restraining Futura from dealing with the reliance, which is otherwise excluded, is something which is upheld. And parties recently have been relegated to SIAC, incidentally, for further arbitration, because emergency arbitration is also an ad hoc step, so to say, not ad hoc, but an interim steps, I'm sorry. So basically, we've drawn from our various provisions without having an explicit provision, as I was saying. And while it is recommended, and we hope that this will form the framework and the bulwark for the emergency arbitrations to be recognized in full force and provide the necessary mechanism so that there is no dispute on how it is to be operated upon. Of course, in the meantime, we can rely upon judicial precedent to utilize the same.
Thank you, Pinky, for that. Very clear. Makhdoom, over to you in relation to investment treaty developments in Pakistan, unless you want to say something about the emergency arbitrator award issue as well.
The emergency arbitrator issue has not crept up in the courts over here as yet. The New York Convention awards have been tested fairly quickly. The first case, which went through the High Court to the Court of Appeal to the Supreme Court, the Supreme Court has clearly said there's going to be a no merits review, and they were fairly quick in enforcing it. So that's a heartening sign. When it comes to investment treaty arbitration, we have had done a number of BITs, and Pakistan initially was lucky enough to escape its first 5 exit arbitrations relatively unscathed. The recent 2 were not such good news, but one of them, the award was negotiated. The settlement was done in great secrecy. We don't know what it was, but that has gone away. And the other is, which was a huge award of $9 billion, that is being negotiated again. And recently an agreement has been signed. So that is now in the public domain.
Right. And in terms of investment treaty law itself, model BITs, anything of that sort in the offing, or as a result of some of these decisions?
Model BITs have been much discussed, and number of drafts circulated at various state levels as well as at the level of lawyers' organizations, but the country has not come up with a model BIT as yet. The Exit Convention has been implemented in domestic legislation, and so has the New York Convention. So that makes those awards enforceable in Pakistan.
Thank you, Malcolm. Anyone else wants to touch on investment treaty developments? Avindra?
No, we haven't actually had those, only to say that most of our BITs have exceed dispute resolution in them. We haven't actually gone all the way in any. I think there was one. Apart from that, we haven't really gone all the way in any of those arbitrations relating to the BIT agreements.
Imtiaz, from the Bangladesh perspective?
Bangladesh has been, recently, our BIT success has been mixed. And most recently, it's not a BIT, but one of the BIT arbitration we lost, and the SIPEM, and that sort of gave a lot of perspective internationally about court intervention into international arbitration and how a court intervention itself can amount to a breach of investment treaty. That was Bangladesh and SIPEM. Subsequent to that, some of the exit arbitration, we have had some success. But one thing I did wanted to sort of quickly touch upon was, this about court intervention and interim awards, which is a big judgment that has come up just this month, actually, where, the position in Bangladesh about availability of interim awards for foreign-seated arbitration has been clarified by a larger bench of the Supreme Court, which has taken the position that if the arbitration is seated outside Bangladesh, then no provision of Arbitration Act, including the interim arbitration and interim measures provision apply other than the enforcement provisions. So we have clearly the Bharat Aluminium kind of stance. However, what the court has done a twist is that the courts will still have inherent power, so to protect the arbitration itself. So they are saying, okay, foreign-seated arbitration, no interim measure. However, local courts, if someone has roguely initiated a local court proceedings, those can be stayed by way of through use of inherent power under the Civil Procedure Code. So I think the mood has been to really protect arbitration and promote arbitration, but no interim measures for foreign-seated arbitration. I think that's a very important development, which kind of touches upon the push towards go to arbitral tribunals for interim awards, because there is a specific provision in the Arbitration Act which deals with interim awards or enforcement of interim orders, not awards, interim orders by tribunals. So I think, what Pinky was saying in like the Amazon case, if cases come to get tested, it will be interesting to see after this larger bench decision.
Thank you, Imtiaz. Pinky, on the BIT front in India,
Well,
it's been slightly hotter, hasn't it?
Yes, it's slightly hotter, and I was, that's why you saw that I was waiting for my turn, if at all you ask me. But no, that's not the thing. See, all said and done, India has been doing brilliantly well on the ease of business. We have risen high up in the ranks, and in all regulatory regimes, we are getting the clearances. The foreign investment has risen both inbound and outbound. We are kind of topping the sequences there. So the point is that at the end of the day, BIT is to secure not only the investor, but it is also to secure the state. I think it's a two-way traffic. So earlier it was always the investor and you save the investor. Personally, I do feel, aside from what India is doing specifically, to say that you really have to protect both parties, because it has to be in both parties' interest. It's a commerce. It's a commercial arrangement. So why should it not work like that? Now, India went through its throes of pain, let's put it like this, starting from Whiten case to Enron to Vodafone. So we've suffered all these issues at the hands of BITs, and some of the clauses that have been the cause and the problems, aside from the fact that delay itself is also another constraint that India has been facing, and we are trying to work our way out of each of these situations. But we did come up with a model BIT. We had about 84 BITs. Several were terminated somewhere during this time of 2015 and 16 when the contemplation came up. The model BIT has come in, and we are in fact engaging in a number of exercises, and we have executed about 6 odd BITs. The numbers are somewhat uncertain, but maybe a couple more. So roughly we have concluded with, let us say, Turkey. We have concluded with places like, I'm forgetting the names, maybe Bangladesh, no, Pakistan, one of them. So we have concluded several BITs, 6 under this model BIT kind of proposition, where we are holding the countries to going to the domestic courts for up to 5 years before exhausting any other alternative remedies. Incidentally, for BITs, the law is very clear. The Arbitration Act doesn't apply to BITs. And that's the way the courts have been construing it, saying it's a separate jurisprudence which must be adopted at its own level. So some of the clauses which are proving to be an impediment, the point is they do not seem to serve the purpose. It is highly arguable. So the most favored nation situation, which talks about domestic engagement and saving people or treating them similarly to domestic parties. I'm not sure it works like that, but that's an argument that has been given always for BITs, that you must have these provisions. We have done away with some of them, but we protected. Expropriation, for example, creeping expropriation. investment into how investment is to be treated, how enterprise has to be interpreted. So we have come up with the model BIT, and we are working on those levels. And at the same time, there's been a tremendous amount of growth in investment. So it seems we are able to secure the party's interest, which is the main object of BITs.
Thank you for that, Pinky. And if you observe the way that the investment treaty decisions have gone in other jurisdictions, even outside of Asia, and even within some parts of Asia, not necessarily South Asia, you see the first phase, which is signing up these BITs with provisions. And not all, I think it's fair to say that not everyone had appreciated the consequences of having those provisions in some of those treaties. And when the claim does come, I think it's taken some countries by surprise for sure, or at least some those in power by surprise. But then it also, to some extent, depends on whether it's a capital importing country or a capital exporting country, or if it's a mix. When it's a capital export, partly a capital exporting country, then the view of the usefulness of such treaties also changes, because you want your nationals to be protected when they're exporting capital into a host state. So it's not binary. It does not, you are always going to be the respondent in that, or the state is not always, your state, or the host state is not going to be the respondent in that sense. So we've seen that, haven't we, across many jurisdictions, and that's a process of evolution. But I guess the model BIT should at least reflect the state's thinking on how to strike that balance between investor and state. I note that we have about 2 minutes left. I know we can continue discussing this for a lot longer, but I would like to take at least one other question that's come through. And this is, I think we've answered, there's a question around, do you think institutional arbitration generally has more weight, credibility compared to ad hoc arbitration? If so, can it facilitate the development of a culture of arbitration whereby the judiciary also adopts a more facilitative and pro-arbitration approach while enforcing arbitral awards in proceedings administered by an institution as opposed to an ad hoc arbitration? So this is for the entire panel. Do you think institutional arbitration generally has more weight, credibility compared to ad hoc arbitration? It's probably going to be the last question we're going to be able to take. So who wants to take this one?
My liner, Nish, on this, I think definitely it lends higher credibility, but that is not to say that ad hoc arbitrations are without any utility and do not serve any purpose. They have their own niche, which probably should remain. However, institutional arbitration per se has a great credibility for people, and everybody has confidence in institutions. And when the path is demarcated and people are sure that they know where they are going, I think that lends to the credibility of the institution, plus the support that the entire infrastructure and other issues would have.
Nish, I'd like to add to that.
Please.
Yes, is to say that, yes, I agree with Pinky. Certainly the fact that it's clothed with the authority of an institution that has supported it, the structure that an institution provides, if the institution has had to intervene with regard to appointment of arbitrators and so on, all of that would add credibility to an institutionalized arbitration. And just to say there also that we were talking about the costs earlier and comparing that, I think the value that is added by that institutionalized arbitration certainly is worth the additional cost, if at all. If you look at it, really, even looking at arbitration broadly, you are removing at least one layer of appeal. That's going to reduce the cost. You're also going to have a situation where it is only the counsel fees are probably going to be the same. The cost of the pretrial steps are probably going to be less than a court proceeding, and you're going to have a final award. So really, it's worth the cost, particularly with an institutionalized arbitration when you compare it to a court decision, both in terms of time as well as executive time and the overall cost to the parties.
Thank you, Avindra. Makhdoom, Imtiaz, final words before we close the event. Makhdoom?
Well, I would second it. I would say that it does have more credibility. Besides that, you get much more of a structure, and the parties are aware of the schedule of fee of arbitration, which helps provide great clarity. Thank you.
I mean, in Bangladesh, ADR were used to term to as additional dispute resolution rather than alternative dispute resolution. And I think institutional arbitration can be an answer to that in many respects.
Thank you, Imtiaz. Panelists, I don't think we could have asked more. That was a very engaging discussion. I hope that audience appreciated the depth and the clarity of the presentation and the breadth of the issues that we've managed to cover in a relatively short period of time. Just remains for me to thank all of you for participating and to thank SIAC for inviting us to present this evening.